Senators, are you ready?
Ready.
Would you mind grabbing that outside door for somebody? Just to keep it a little bit more peaceful in here. It's okay. Are you ready? All right, I'll call to order the subcommittee for Senate Study Bill 3039. This is a bill, affirmative bill proposed by the Iowa Campaign Ethics and Campaign Disclosure Board regarding the disclosures that would be required for the use of what they're defining as synthetic media. Any opening remarks from either of my Senate colleagues?
Happy to listen. New definition.
Nothing.
Yeah.
Nothing in the opening here.
Very good. And I'll turn to the department or the board to talk about the bill. And I don't know if this is popular online, but might as well have a microphone.
All right. Good afternoon. I'm Erica Eckley. I'm the director of the Iowa Ethics and Campaign Disclosure Board. This is a bill proposed by our board to address what we are defining as synthetic media. This would be any media that creates a false image of something that didn't occur in campaign materials, requiring a disclosure that it is synthetic media, similar to what you would do for an attribution statement. Campaigns are familiar with the requirement to do attribution statements of who paid for an ad. This would be a similar requirement for transparency of just disclosing that it is synthetic media. There's a definition of synthetic media in it. We did have some conversations with some broadcast, newspaper, and internet providers who would be the ones publishing this media on behalf of those candidates or other individuals. And they were concerned with the definition of who was a responsible person. So that's why I've included an amendment to make it clear that it is the person who has actually created it or paid for it, rather than the provider, the newspaper, or the broadcaster who has the responsibility for that statement. I'm happy to answer any questions. I will say that a number of states have similar disclosure requirements for transparency for the public, and we are following examples from those other states.
Any questions for the board? Seeing none, go around the room and please introduce yourself, position on the legislation, and any comments you might have.
My name is Matt Chapman. I'm from Waukee, Iowa, and I think what we call this is like AI slop would be the terminology for it. Synthetic, not real. I think at the very least, we should do this. Have that. I think it should be completely banned from any kind of political advertising at all. Thank you. Thank you.
Thank you.
Thank you. Sydney Gangstead with the Denton Davis Brown firm. We represent the Technology Association of Iowa. First, I wanted to thank the Ethics and Campaign Disclosure Board. We had productive conversations with Director Eckley in advance of the legislative session. Definitely understand the goal here. And generally, TAI, we are very supportive of any efforts to promote transparency in political communication. I think for us, it's very important that we have clear definitions and obligations, and that we make sure that all those obligations are feasible, not only for technology providers, but also for users of digital content. I wanted to also thank the director for the amendment. Just something to remind, just kind of as a reminder here when we're talking about campaigns. Campaigns and committees are the entities that control that political messaging. So technology vendors and platforms that provide general purpose tools should not face any indirect liability or compliance burdens. And so appreciate any tweaks that we can to make that more clear in the legislation. And I should have started out with, we are currently registered undecided on the bill. Thank you for your time today.
Thank you. Mr. McKinney.
Thank you, Mr. Chair. Members of the committee, Matt McKinney on behalf of Google. We are registered undecided on the bill. I'll echo the comments of Sydney and the appreciation for Director Eckley and the Ethics and Campaign Disclosure Board's willingness to look at an amendment to provide clarity around who exactly is responsible and who's not responsible. Again, Matt McKinney, undecided.
Thank you.
Hi, Dustin Miller,
Mr. Miller.
representing the Iowa Newspaper Association, who's registered against, and the Iowa Broadcasters is registered undecided. Don't take any notice to their registration. It's just simply before we have conversations with the board. Greatly appreciate what they're offering. Obviously, the whole intent of some of these AI things is to fool people as to the reality, and so certainly we will have people that may get fooled and just don't want that liability put on the folks for putting this. So greatly appreciate the amendment that they're offering.
Thank you.
Good afternoon. My name is Jake Frederickson, representing Echo Star Dish TV. We had sought clarification on who the responsible party was. I haven't had a chance to read the amendment yet, but we appreciate the proposal and take a look at it on clarification on what a responsible party is.
Thank you, Mr. Frederickson.
Kevin Chamberlain, Bitches Get Stuff Done. We are registered in favor of the bill, and for multiple reasons. First of all, I hate AI. Second of all, Sora is very easy to manipulate people, and it's very easy to just trick people. This bill makes sense because in a tumultuous, sorry, my words are failing me, campaign cycle, it's easy to be fooled by, I hate to say it, fake news, but Sora and OpenAI sources just make it worse. So having a disclosure on each campaign commercial that says AI was used, because synthetic media is AI, is very sensible, and we are in strong support of this bill.
Thank you. Looks like we have a couple of people online with their hands up. If you do wish to speak online and you haven't already put your hand up, please do so. But we'll first ask Mr. McInerney from Johnson County to unmute himself and add any comments to the discussion. Did you ask?
Yes, I did.
Mr.
Okay,
McInerney?
there you go.
There. Gotcha.
All right. Can you hear me? Okay.
Yes, sir.
Okay, thank you. My name's Thomas McInerney. I'm a resident of Iowa City, and I support the goals combating the AI-generated deepfakes and campaigns as a timely step, as it's like 28 other states have now regulate this. So I understand this timely event here. However, to be more effective and constitutionally sound, I urge revisions to address the key weaknesses. And just to go through them, the weakness, one of them is the constitutional risks from the lack of exemptions. Without explicit carve-outs for satire, parody, or humorous content, the bill would chill protected speech under the First Amendment. Courts have struck down similar laws for overbreadth. So the point is, humor and memes hold leaders accountable, and it builds democratic resilience. And so I would say that add to the exemption, this section does not apply to satire, parody, humorous, mimic, or editorial content not intended to deceive voters. This is modeled, there's a couple of states that have modeled this similar language into their law. Second item is the vagueness in disclosure requirements, predominantly include, end quote, is undefined. It's risking arbitrary enforcement and legal challenges. Without specific formats, compliance could be inconsistent across media types. So I would revise, specify the format to be like 4-second on-screen text in the video, at least 4% of the height and high contrast, spoken disclaimers in audio, or AI-generated links to social media. Such language also is another state, I believe Washington, Senate Bill 5152, I think, has this for clarity and defensibility. Also, the third item, reliance on criminal penalties, jumping straight to serious misdemeanors or willful violations could deter even good faith actors without a tiered approach for education. So there's no civil options mentioned. So I would revise it to add civil penalties first, like $1,000 for the initial violation, escalating to $5,000 to $10,000 for repeat, and then reserving the criminal charges for knowing fraud. So that and the other item I would say is also the broad scope without intent or time limits. This applies to all published material, anytime without requiring intent to deceive. This has had potential capturing non-deceptive uses. Also having no 90-day pre-election window, this is the highest risk period. So I would recommend revising, limiting to electioneering communications within 90 days of the elections, require, quote, knowing or reckless, end quote, intent to deceive. This narrows tailoring, aligned with Arizona's Senate Bill 1359, and it reducing the federal preemption risks from Trump's AI litigation task force. So I think I encourage this. I think these changes would make SSB 3039 more robust, effective, and resilient to lawsuits, drawing from proven models in other states. They're better protect the voters from deception while safeguarding free expression, ensuring Iowa leads on AI ethics without stifling democracy. So I encourage the subcommittee to advance with this bill SSB 3039 with these amendments. And I'll happy to provide additional information for follow-up. Thank you.
Thank you, Mr. McInerney. Pam Taylor, your hand is up. We're going to ask you to unmute. Pam, can you hear us? We cannot hear you. Try again.
Hello, I'm Pam Mackey Taylor. I represent the Iowa chapter of Sierra Club. We are supportive of this bill and encourage its passage. Thank you.
Thank you. I'm not seeing any other hands up online at this time. I'll give you another moment here if you want to weigh in. Going once, twice. Forever hold your peace. Sold.
Would you mind if I responded to a couple of Mr. McInerney's?
Please, we have time. Take the microphone, and we're not going to make this a debate, so but it's your proactive bill, so I'm happy to hear your response.
So I just want to respond to, he brought up concerns about this being an overreach. This is related only to published materials as defined in 68A, which would be strictly campaign materials advocating for or against a candidate or a ballot issue. It would not apply to general satire or other concerns that he raised under the First Amendment. I also, in the explanation, it includes criminal penalties. Those are what are in the statute. However, this would likely come before the Ethics and Campaign Disclosure Board for review. We do not, we would have civil penalties. We would work with the parties. And if there were any criminal aspects that needed to be done, that would be done through the Attorney General or the County Attorney. But that is what is existing in the statute already. That is not something we are asking to change or include in this. So thank you for letting me comment.
Yeah, no, thank you. And maybe hold that. I've got a couple of questions. Candidate is a defined term in Iowa code. Is that right?
There's under 68A, there are the responsible parties with the attribution statements. The attribution statements are defined by who is paying for the specific campaign materials there. So individuals, committees, parties, or corporations if it's an individual expenditure.
And the reason I ask or seek a little clarity is we've seen on X, or at least that's where I've seen it, memes that are put out by a political candidate, and they're not necessarily campaign communications in the strictest and most historic sense, which obviously we're in a new age, as people have alluded to. But whether that's everyone from the president to the governor of California and others have sort of put memes out. How do you see those? If you're a candidate, sort of broadly speaking, and you have a Twitter account, X account, and you put a meme out that uses AI or digital whatever Pixar stuff, would that require disclosure? Would it not require disclosure? How do you see that being
So we see.
interpreted by the
Yeah,
what the
so
board?
we see this bill, thank you for that question. We see this bill as,
Thank you.
sorry, we see this bill as similar to if it requires an attribution statement. So it is expressly advocating for or against a candidate or a ballot issue. And it's using this synthetic media, which could be Photoshop, not just AI, for creating a false image. It would need to have that disclosure on it. We're not looking to regulate general speech unless it's a campaign advocating for or against a candidate or a ballot issue.
So fairly narrow. Very good. Any other questions, senators, from either of you, please?
So,
Senator
and
Whitman.
thank you, Mr. Chair. You explained it a little bit. My first question when I read the bill was the penalties, but I went to the end of the code, .701 in your code, that identifies that it is a serious misdemeanor. You mentioned some other potential ways in which you would work with an individual who had violated this. Can you go through that again?
So the closest example I can give is the attribution statements. So our office receives complaints if there is campaign materials advocating for or against a candidate or ballot issue that doesn't have that paid for by. We work with those individuals. We do currently have administrative rules requiring disclosure to address that concern. If somebody is unwilling to make that additional disclosure or to resolve the failure to put that attribution statement, then my board can look at it and review it and provide fines or penalties for that. The board does have jurisdiction over this, and so they would be able to do that. The code itself does have those criminal penalties in it, but my board, for the most part, tries to resolve the issue before moving toward those types of concerns.
And so you mentioned administrative rules, that some of this is spelled out in administrative rules. Is that correct?
For the attribution statement, we do have a procedure for somebody to fix failure to put an attribution statement in there. They have to either publish something in the newspaper or redistribute the information to the people that received it with that clear attribution statement on it. So our board could certainly look at administrative rules and putting something similar for this, but I have not had a discussion with them about that.
Sure. Thank you. Thank you. I think it is necessary to have some guidance in regard to any kind of manipulation of a person's voice or whatever. I appreciate your efforts with this. I'm anxious to hear Thomas mentioned, McInerney mentioned that he would provide some information. I'm anxious to see, hard to identify other states and what they're doing, but I do feel that this is an important topic. Thank you.
Senator Rickman.
I'd like to see it actually go a little further and not allow AI images at all, but happy to further the conversation on this and sign off on it.
One final question. Apologies for the belated nature. Is this something that we've seen or the board has identified, like where we have an example in Iowa that it's happened, or is it, something that came up in Iowa?
Is this preventive or is
it reactive?
I am not, I've been in the role since July. I did not see anything, nothing was brought to our attention in this last election. It's discussed a lot across the country. We went to a conference with other ethics and campaign disclosure boards. This was a topic of conversation that they're seeing, and we're trying to, with this bill, make sure that we're not impeding on First Amendment rights, but providing that transparency for the public.
Yeah, I think it's a important and fine line to walk between speech and political speech and how important that is for our country, and at the same time protecting the public and with the technology that exists in terms of AI and deep fakes and all the other things that are fast advancing. So appreciate the efforts. You know, obviously we're going to keep the conversation going. My intent today is to sign off with the amendment that you have, and we'll talk to committee and committee chairs and work it through the process. So appreciate everyone and the thoughtful approach that everyone takes. Thank you.